Beleza.
Ah.
Okay, so welcome everyone. We'll be starting this hearing between Orchis Worldwide Limited and Darwin Natural Food PLC. It's SIA case ARD 1991-25-VIS. Luis Peretti, I'm a partner at Souto Correa. Before we begin the actual works of the hearing, I'm honored to introduce to you this very start panel that we have today. So starting with Adriana Uson, who's joining us live from New York. Do you hear us well, Adriana? It looks like yes.
Yes, I can hear you.
Adriana, thank you for joining us today. For the benefit of those who still do not know you, Adriana is the director and head for the Americas of the Singapore International Arbitration Center, the arbitration center under which rules we are arbitrating today. She's a former SIAC Secretariat Counsel, and she has administered more than 200 SIAC or UNCITRAL cases and contributed to the SIAC rules from 2016, which are also under discussion today in our hearing. She also contributed to the investment arbitration rules of 2017 and the practice notes on third-party funding from the SIAC. She's a fellow of the Singapore International of CIARB, and she's active in the Young SIAC and CIARB Singapore Young Members Group. Adriana, it's a pleasure to have you with us today. Thank you so much for coming. You have been to Brazil last year, and we hope to see you again here with us very soon.
Thank you, Luis. Thank you for having me here today.
On my left-hand side, our very good friend, Pedro Martini, who's a fellow at the Chartered Institute of Arbitrators. He's an attorney admitted in Brazil and New York. He holds an LLM from Berkeley, and he's a graduate from the Federal University of Minas Gerais. Pedro's practice, as clearly Gottlieb, spans litigation, arbitration, regulatory enforcement, and cross-border matters. And he has experience with arbitrations involving M&A, private equity, construction, and he worked also in many cases relating to corruption, DOJ, SEC matters, also on US securities frauds and class actions. And for those who do not know, but maybe this is also old news for us in Brazil, Pedro is one of the founders of Bacamaço, like the company, fictitious company that is always used in the Brazilian arbitration competition every year. So although he is young, he's one of our pioneers in competitions, moot court here in Brazil. So we are also honored to have you with us today, Pedro.
Thank you, Luis, very much.
Okay, so starting introductions from the teams, we have on the right-hand side as claimant Puki today, if you want to introduce yourselves.
Good afternoon, members of the tribunal. My name is Mariana Carreira, and I'll be addressing claimant submissions on the procedural aspects of the dispute, whilst my co-counsel, Henrique Padilha, will be speaking on the merits.
Honorable arbitrators, opposing counsel, good afternoon. My name is Ana Teresa Ortiz, and I will address the interests of respondent Darwin Natural Food on the procedural issues, alongside Ms. my co-counsel, Maria Vilas Boas, who will be addressing the merits of the case.
We understand that in this case we have some procedural issues. Have the parties discussed the order in which they want to conduct the presentations today, starting with respondents?
Mr. Arbitrator, regarding time allocation, the parties have reached an agreement. On the procedural issues, respondent will start submissions for 40 minutes, followed by claimant submissions for 40 minutes. Then, respondent will present its rebuttal for 1 minute, followed by claimant's rebuttal for the same time. On the merits, the order is reversed. 14 minutes for claimant, followed by 14 minutes for respondent, 1 minute for rebuttal, and 1 minute for rebuttal.
Okay. Anything else before we begin? Adriana? So I think we'll be hearing respondents on the jurisdiction then for 14 minutes. Ms. Ortiz, floor is yours.
Members of this tribunal, claimant attempts to shape these proceedings to its own advantage, even if that requires revising procedural rules and challenging the discretionary authority of this arbitral tribunal. Through its interpretations, claimant seeks to obscure the reality of his case, its severe financial situation, and the need to win these proceedings at any cost. However, a party cannot evade the rules it force when it suits its own interest. As such, respondent will make two submissions. First, the 2025 SIAC rules shall apply to this arbitration, and second, that the arbitral tribunal should order the disclosure of the third-party funding and the insurance agreements, irrespective of the applicable rules. Before entering respondent's first submission, allow me to contextualize the procedural issues. In December 2021, claimant entered into a contract with Botanical Garden, respondent's predecessor, for the delivery of vanilla orchids. The parties agreed that any future dispute would be resolved under the SIAC rules, as well as the parties would attempt mediation before arbitration. Then, the arbitration agreement was not discussed any further, even when respondent amended the contract. Now, not only does claimant seek to apply an outdated version of the SIAC rules, but he also objects the disclosure of the agreements which directly impact respondent in the present proceedings. Members of this tribunal, the 2025 rules shall apply according to the interpretation of the Articles 8.1 and 8.2 of CISG. As such, the parties' intention about the applicable version of the SIAC rules was not clear, and, in the sense, this tribunal should interpret according to the understanding of a reasonable person. Honorable arbitrators, regarding what was agreed in the sales agreement, respondent would like to emphasize that the parties chose the most up-to-date SIAC rules to rule these proceedings. In the sense, Article 8 of CISG establishes the rules of interpretation of this case. First, Article 8.1 establishes, and I quote, "These convention statements made by another conduct of a party are to be interpreted according to his intent, where the other party knew or could not have been aware what that intent was." Members of this tribunal, the intention of the parties of which version of the SIAC rules should be applicable is not clear. In any moment, the parties expressly mentioned the application of the 2016 SIAC rules. The arbitration clause, which states current SIAC rules, must be seen as a referral to the rules in force at the commencement of the arbitration. That means the most up-to-date rules. Members of this tribunal, it's important to highlight that SIAC provides that the rule that shall be applied is the rules in force at the commencement of arbitration, unless otherwise expressly agreed by the parties. Honorable arbitrators, in any moment, respondent's predecessor or claimant or respondent mentioned the word 2016.
Ms. Ortiz, if I may, I follow your rationale for interpreting the arbitration agreement, but I'd really like to know from the onset in this discussion, why is your client interested in the application of the 2016 rules? What is the actual benefit or the detriment in which would arise if we were to apply the 2025 rules?
Mr. Arbitrator, the 2016 rules provides in the disclosure of documents that this arbitral tribunal has the power to disclose any documents that are relevant to the outcome of these proceedings. Otherwise, the 2025 rules of SIAC provides in Article 38.4 that this arbitral tribunal has the power to disclose the details of a third-party funding agreement. In the sense, it's better for respondents to apply the 2025 rules because in these proceedings, claimant seeks to apply the 2016 rules because they provide general rules of disclosure. And in this case, it's better for claimant to rely on more general rules than those rules that explicitly provide for the disclosure of details of third-party funding agreements. Members of this tribunal, in this sense...
Ortiz, I'm sorry to interrupt you. Just to follow up to my colleague's question. We understand that it's respondent's position that claimant is required to disclose the relationship with a third-party funder and the agreement and so on, regardless of the rule that is applicable. So why should we just skip to that? Or do you have any other reason for the 2025 rules to be applicable?
Honorable arbitrator, in this case, we understand that the 2025 rules shall be applied because it's the rules that are applicable at the commencement of the arbitration. And in your opinion, yes, respondent understands that the problem of applying the 2016 rules is in regard of the disclosure of the third-party funding agreements. But we need to discuss this, the applicability of which version of the SIC rules, because claimant started the proceedings under the 2016 rules, which is not correct. In the sense, members of this tribunal, I would like to point you to Article 8.2 of the CISG, which provides that if the intention of the parties is not clear, this tribunal shall give recourse to the understanding of a reasonable person. Members of the tribunal, the understanding of a reasonable person is the understanding that the applicable rules are the applicable rules in force at the commencement of the arbitration, which is the most up-to-date rules, the 2025 SIC rules. In this regard, I would like to bring this tribunal's attention to the understanding of a reasonable person. In a case judged by the Singapore High Court, where there was in the arbitration agreement the statement that the SIC rules currently enforced must be applied, the Singaporean tribunal understood that, and I quote, "This indicates that the parties intended for the most up-to-date rules to apply when proceedings were commenced. They did not specifically carve out from that express incorporation some historical and since amended provisions relating to the appointment of this tribunal." Members of this tribunal, it is clear, even for the understanding of a reasonable person, that if a party has not explicitly decided to apply a version of the rules in force at the commencement of the arbitration must be applied.
Counsel, just to interrupt you for a bit here, how do you deal with the claimant's argument that the multi-tier clause reflects a shared intention to stop the time running at mediation?
Honorable arbitrator, regarding the two-tier dispute resolution clause, respondent understands that, yes, mediation is a part of the dispute resolution process, but it's not the beginning. It doesn't determine the beginning of the arbitration proceedings. When the parties choose to attempt mediation before arbitration, they were not choosing one procedure or one arbitration proceedings with the mediation, but the first attempt to mediation and the second attempt to arbitration is a two-step dispute resolution process. In this regard, members of this tribunal, in the sense, if the parties wanted to submit to a specific version of the SIC rules, they could have simply referred to the 2016 rules. When respondent amended the contract, it followed the prevailing legal understanding that the most up-to-date version of the SIC rules would apply, as the parties had chosen the SIC rules irrespective of its version. Members of this tribunal, irrespective of the applicable SIC rules, the arbitral tribunal should order the disclosure of the third-party funding and the insurance agreements as requested by respondent. Honorable arbitrators, this tribunal has the power to disclose the funding agreements at both the 2016 and the 2025 version of the rules, and such disclosure is relevant and material to the outcome of these proceedings. Members of this tribunal, according to Article 27 of the 2016 rules, the arbitral tribunal shall disclose those documents that are relevant to the outcome of the case. Otherwise, the Article 38.4 of the 2025 SIC rules provides that the arbitral tribunal has the power to order disclosure of the third-party funding agreements, its details, its contact details, and the existence of them. If it is clear that this arbitral tribunal has the discretionary power to order the disclosure of said agreements, it's important to pay attention to the relevance of those documents, Members of this tribunal, respondent contends that disclosure should be made as it is relevant to these proceedings. Under the IBA rules, the commentary evidence must be relevant and material to the outcome of this case.
Mr. Chase, just before we get there, I think I have a couple of questions here. So under the 2025 rules, is the claimant required regardless of what the tribunal decides? Is it an automatic requirement, or does the tribunal have to decide to order the claimant to show those documents?
Mr. Arbitrator, the tribunal has the discretionary powers to order the disclosure of said agreements. The difference is that the 2025 rules explicitly provides that disclosure and the details and the disclosure of the details of the agreements. On the other hand, the 2016 rules is more open for interpretations of claimant, and that's why the 2025 rules are important to these proceedings. Honorable arbitrators, the third-party funding agreement is the only evidence capable of demonstrating that claimant has the financial capacity to pursue this arbitration, including the ability to bear the costs of the proceedings. In this regard, I would like to ask this tribunal to follow me to page 58 of the files, which is page 60 of the PDF, and please let me know when you are there. For reference is the procedural order number 2, which contains a series of uncontested facts provided by this arbitral tribunal. I see that you accompany me, and I would like to quote clarification 20. If you could follow me to clarification 20, the second sentence, please. You follow me? Perfect. In March 2025, a former manager of claimant who was fired for embezzling funds sabotaged greenhouse controls, destroying 15,000 orchids to be delivered between 2025 and 2027. Claimant's insurance likely will not cover the losses, leaving claimant solvent only until June 2026. Not only it is clear that claimant could not pursue this arbitration without financial support, but also that it is solvent at least until 2026. Members of this tribunal, the disclosure of the third-party funding agreement and the insurance agreement is relevant to the present case to support respondents' potential request of security for costs, which is provided in the Article 48.1 and 48.2 of the SIEC Rules 2025.
Ms. Ortiz, if I may, I can clearly see the relevance of third-party funding for matters of conflict of interest and for deciding if the arbitral panel is neutral or not. But in your request relating to costs, I'm having a little bit of difficulty in understanding respondent's position here. You don't seem to have any counterclaim the merits that you would have to enforce against claimant. And apparently, I believe that the risk of failure to pay the arbitration costs would likely be solved by the SIAC rules themselves. So why does respondent have an interest in ensuring the payment of the arbitration costs here? I'm struggling to understand this point.
Honorable arbitrator, it's important to highlight that respondent in these proceedings has the right to reimbursement of the cost of these proceedings. If respondent wins this award, claimant will have to pay the costs of these proceedings to respondent. But the problem is, it is not clear that that claimant has the financial capacity to pay the costs of this arbitration, including with the financial support of ATJ funding and literature. Members of this tribunal, I see that my time is elapsing. I would like to ask you one additional minute to finish my submissions. Thank you. In this regard, members of the tribunal, it's important to request the disclosure of said agreements because the ATJ insurance and the ATJ funding may not cover all of the adverse costs, and further, given claimants insolvency, it may not be able to afford the premium. Members of this tribunal, it is important to understand that respondent cannot pursue these proceedings blind by the possibility of not being paid by its costs. And in this sense, respondent would like to reinstate its submissions and respectfully request this tribunal to rule on its behalf. Thank you.
I have a follow-up question, may I?
Go ahead.
Okay. Counsel, you're departing from the assumption that you will be entitled. That's fine. If you win, we may decide on costs, allocate costs, and so much. But it seems to me that you are asking directly for the totality of the information about the funding agreement. Shouldn't this tribunal first consider whether you're entitled to financial information to see if the claimant has the financial capability, and only then, if we're not satisfied, then we move on to the funding agreement? And my second question would be, would respondent be satisfied with limited information from the funding agreement so that we can redact parts that are not relevant to your request regarding the costs?
Mr. Arbitrator, I'll answer your question in the order they would address it. First, regarding the financial capacity of claimant, it is important to respondent to know the financial situation of claimant because respondent has the right to order security for costs in these proceedings. And to make such order, it's important to have the substance of the financial situation of claimant and consequently its incapacity to pursue this arbitration. Now, regarding the possibility of a master's privilege, respondent agrees with that possibility, and the only worry in these proceedings of respondent is regarding the financial situation and the financial details of respondent of claimant in these proceedings. So, if this arbitral tribunal suggests a master's privilege, respondent doesn't discard this suggestion. Thank you.
Just a follow-up question. Is it correct that the respondent receives financial support from its parent company?
Madam Arbitrator, yes, respondent receives financial support from its parent company, but in this case, it's not a third party. It's the same company that Darwin Natural Food is in the holding. In this case, in these proceedings with the financial support from a Darwin Natural Food, it doesn't have an external intention or an external funding unless that the same company that respondent participates. So the interest of Darwin Natural Food holding is to pay all the costs because it is its company.
Thank you.
Anything else from the tribunal right now? I think we can also ask questions after the rebuttal. Ms. Carrera, are you doing jurisdiction?
Yes.
So after you drink your water, I'll start the 14 minutes.
So once again, good afternoon, members of the tribunal and opposing counsel. Members of the tribunal, the only reason we're here today discussing the jurisdictional aspects of the dispute is because it is respondent that is attempting to subvert proceedings and shape it to its fancy by flagrantly disregarding the parties' agreement in order to try and force claimant to disclose confidential, sensitive information, which shall not prevail. As such, on the procedural issues, claimant will demonstrate, first, that the applicable rules to this arbitration should be the SIAC rules of 2016, and second, that the tribunal should not grant respondent's request for disclosure of claimant's funding and insurance arrangements. Moving to my first submission. Respondent argues that the applicable rules to the arbitration would supposedly be the rules of 2025, according to the intention of the parties, and the commencement of proceedings. As for the argument regarding the commencement of proceedings, claimant doesn't contest. Arbitration started in 2025. However, respondent submissions regarding the intention of the parties for the arbitration is entirely misguided. This is because although claimant agrees with counsel for respondent in the sense that the intention of the parties should be interpreted here according to the CISG standards, respondent's interpretation does not reflect what was actually agreed during negotiations. In this sense, respondent brought that correctly that Article 8 of the CISG establishes first an objective requirement for understanding intention and then a subjective requirement. However, claimant's contention is that under both these requirements and the requirement of paragraph 3 of Article 8, which is that all relevant circumstances of the case, including negotiations, should be taken into account, the parties did intend to specifically apply the rules of 2016. As for the objective interpretation under the CISG, respondent stated that the parties never expressly mentioned the rules of 2016 in the contract, and that would then be against the SIAC rules scope of application in the sense that parties would supposedly have to expressly agree otherwise. However, this is not what's written in the rules. For instance, in Rule 1.2 of the SIAC rules of 2016, it reads, and I quote, "These rules shall come into force on 1st of August 2016, and unless otherwise agreed by the parties, shall apply to any arbitration which is commenced on or after that date." The writing is very similar in the 2025 version. The requirement for an express agreement otherwise simply doesn't exist. And in the sense, the parties' intention, although they didn't explicitly mention the rules of 2016 in the contract, was objectively to apply the 2016 rules. To illustrate this, I would like to ask the tribunal to please follow me to page 21 of the case files or 23 of the PDF. If the tribunal is with me. This is an email sent from the Botanical Gardens representative to claimant when they were originally negotiated the agreement. In the first paragraph, with starting in the third line with the word "the," it reads, "The current version of their arbitration rules with the AMA protocol is acceptable to us, provided that we can agree on a modified version of the AMA protocol." Ms. Gobley was referencing specifically the rules of 2016. And this is incredibly important because the same email shows that the Botanical Garden had never agreed to enter into international arbitration before. The only reason they choose to do so and change the policy of a public company was because they specifically agreed with the rules of 2016. This decision was so relevant that it required board approval, and claimant agreed. In fact, the word "current" in this email is confirmed to be referencing the rules of 2016. Now moving to the...
Ada, I'm sorry to interrupt you.
Sorry. Oh, sorry.
Go on, Ms. Uson.
Yeah, so I wanted to ask, should statements by a third party, in this case, Ms. Gobley, but in a prior contract, bind the respondent under this agreement?
In this case, yes, Madam Uson, because respondent acquired the Botanical Garden and then took over the agreement that became the sales agreement. Many clauses of the contract were changed, but the dispute resolution clause remained the same. Furthermore, respondent had access to all of this negotiation history, and by signing the contract, it consented.
So is there my question was going to be basically the same that my colleague just made, but my follow-up question to you is there anything in the record showing that respondent, the one that is here, actually was aware of this context and of the specific intent to choose the 2016 rules?
Mr. Arbitrator, if you could follow me and the rest of the tribunal, please, to page 56 of the case files or page 58 of the PDF. 58 of the PDF. And in clarification number 6, the answer is the question. Did respondent have access to the negotiation history between claimant and the Botanical Garden, in particular the emails of Ms. Gobley of 26 November 2021? The answer is yes. Respondent did have access to these emails, though the rest of the clarification does go on to say that it is unclear whether respondent read it. That was its burden as a diligent party. In fact, it acquired the whole company of Botanical Garden. And since the submission to an international arbitration institute was so huge that it required board approval, its claimant's reasonable understanding that respondent was aware of what that meant, especially considering that respondent made several suggestions to other clauses within the sales agreement, but agreed to leave the rules of the clause 16 intact. This is especially relevant when we go to the subjective standard of the CISG. In the sense, claimant doesn't contest respondent's affirmation that the common practice is to always apply the most updated set of rules. The problem here isn't the possibility of updates. The problem is very objective. The parties simply did not agree to that. This is especially relevant because claimant and the Botanical Garden, during negotiations, changed the wording of the SIAC model clause. The SIAC model clause typically reads, the applicable rules are the rules for the time being enforced. But the claimant and the Botanical Garden changed those words to mean current. The only other time they use current in the case files is in reference specifically to the rules of 2016. So either objectively or subjectively, it doesn't make sense that the parties would agree to apply a set of rules they hadn't specifically revised, considering how sensitive that information was. As respondent has also never contested or questioned what the word current meant in the agreement and why it was different to the SIAC model clause, claimant understood that the respondent agreed with the application of the SIAC rules of 2016 indefinitely to the arbitration. Which is why claimant reinforces its submissions in the sense that the tribunal should declare the applicable rules to this arbitration as being the rules of 2016. Now, moving to my second submission, respondent argues that under either set of rules, the rules of 2016 or the rules of 2025, it's this request for disclosure of claimants' funding and insurance arrangements should be granted. But this is not the case. Under the rules of 2016, there are no specific provisions on third-party funding. That means that there are also no specific obligations on claimant to divulge its information. What we have are the SIAC practice notes issued in 2017 that do apply to the rules of 2016. However, the only obligation there is for the disclosure of existence and identity of the funder, which claimant has willingly done of its own accord. This is because claimant wanted to facilitate the answer of a possible conflict of interest in the arbitration. And the tribunal has already clarified that it has no conflict and it's fully independent. And the ICCA Queen Mary Task Force, for instance, when analyzing many cases involving third-party funding, found that the overwhelming reason, and basically the only reason for disclosure, is to avoid conflict. And that question is already answered. Still, even if...
I'm sorry. I think Ms. Ortiz made an interesting point that part of the reason the information is being sought is not for conflicts. It is because there is an interest in understanding the financial capacities of the claimant to be able to pay a potential award on the costs. Mm-hmm. So if that's the case, do you have any answer to that?
Yes, Mr. Arbitrator, that leads me precisely to my second point, which is even that under the 2025 rules, then the disclosure should still not be ordered. Counsel for Respondent's argument is made on the basis of Rule 38.4 of the SIAC rules of 2025. However, those rules do not give the power to order disclosure of the arrangements themselves, only the information contained within them. What Respondent
Counsel, sorry, just to interrupt, aren't these inherent powers of the tribunal?
Madam Arbitrator, the tribunal could, of course, using its inherent power, order the disclosure of the arrangements. However, the fact is that even within the writing of the rules, that is contingent on the situation where it is appropriate, using the language contained in Rule 38.4 itself. What claimant contends here is that it's not appropriate, even though despite Respondent's allegations that it has a concern regarding the payment. The payment of the proceedings, claimant went after a third-party funder and an insurance agreement precisely to ensure that it could pay that it could pay costs and an eventual adverse costs. In the sense, I would like to direct the tribunal's attention to the same clarification that counsel for respondent brought, which is in page 57 of the case files, or 59 of the PDF. I'm sorry, 58 of the case files or 60 of the PDF. This is clarification number 20. When reading this clarification, respondent read the part in which it says that a claimant would be left solvent only until June. However, counsel for respondent left two very important parts of this clarification out. The first is that just right after the question, it reads in the first line, that, the question being, could claimant pursue the present claim without the financial support of ADJ funding? And the answer is probably not. Despite what respondent has made it seem like, claimant is not confirmed to be solvent. Its insolvency is likely, but not a confirmation. Furthermore, at the end of the same clarification, in the last line, in the second to last line, starting with claimant, it reads, claimant contracted with both ATJ funding and Litshore in February 2025 to remove cost risks associated with the dispute and the arbitral proceedings from its balance sheets. Claimant's interest in hiring the funder and the insurer was precisely to make sure that it would be fully funded and fully insured throughout proceedings. Respondent, in fact, in the Escosal v. Italy case, the respondent had asked for the disclosure of claimants' funding agreements and for security for costs. However, the tribunal in that case found that precisely because the claimant had already hired and after the event insurer, then that would not be necessary because that indicated that it would be covered throughout the proceedings.
Counsel, do we have in the record any representation by anyone, by claimant, that the agreements actually cover a potential award for costs? Is your statement sitting here today that all the arrangements are that there will be a payment and just that as a representation by the claimant?
Mr. Arbitrator, the information that we have in the case files and that claimant is comfortable divulging today is that although ATJ funding doesn't cover adverse costs, it has hired Litshore precisely to make sure that it covers adverse costs. In fact, in the same page that I just brought the tribunal's attention to, page 58 of the case files or 60 of the PDF, clarification number 25. Did ATJ financing have any involvement in arranging to require the claimant to obtain the adverse costs insurance policy with Litshore? The answer is no. Claimant approached Litshore after ATJ informed it that including a potential adverse cost coverage in the budget would make funding too expensive. Claimant went after the event insurance all on its own to ensure payment. If I could just ask, being conscious of my time for an additional minute to finalize the submission. Yes. Thank you. Claimant wants to pay all costs in this arbitration because it wants to win the arbitration. It wants to claim damages. There is no reason to start this whole dispute for claimant only to back out due to lack of funding. It has been diligent up until this point, including in the contract it had with this respondent, and it will continue to be diligent throughout. Respondent's request for disclosure only serves the purpose of delaying proceedings and accessing incredibly sensitive information regarding the risk assessment made by claimant's insurer and funder, which could be extremely detrimental to claimant throughout the proceedings.
At that point, counsel, I just would like to ask you the same question that Mr. Martini asked to respond, which is, if we were to consider other options like redaction or an in-camera review by the tribunal, would that be acceptable for claimant?
Just to confirm that I have time to answer your question.
Yes, please.
Thank you. Mr. Arbitrator, I would have to confirm with my client if that would be the case. Prima facie, I could tell you that we would be comfortable with revealing information to the tribunal's eyes alone, but even then, the tribunal could infer a risk assessment from this information and become prejudiced against claimant, which could be a problem. So at this point, claimant's answer will be no. Thank you. And with that, I reinforce my submissions and thank the tribunal for its time.
Any additional questions to Ms. Carreira at this moment?
All right, Timo.
So we'll now hear the rebuttal from respondents. These are his 4 minutes.
Members of this tribunal, claimant bases its entire claim that disclosure is not relevant because of a word as vague as probably, refusing to disclose the only documents that could bring certainty about claimant's financial situation. Thank you.
Questions? Carreira, Sir, rebuttal for 1 minute.
Claimant has gone after an external funder and an insurer to make sure that whatever financial situation it's facing will not be a problem throughout the proceedings. Respondent is attempting to pose a smokescreen in his arbitration and make it seem like claimant wants to do an arbitration hit and run. This is not the case. Claimant wants to stay here throughout the proceedings and win this case, and therefore disclosure will not be necessary. Thank you.
I may have one follow-up question.
Of course.
Very quickly to Mr. Ortiz, actually. Mr. Ortiz, what is respondent's response? What is your position on the claimant's argument that it is enough to know that the insurance is to cover adverse costs? Doesn't that respond to the core concern that you have about the capacity of paying and adverse cost awards?
Honorable arbitrator, Mr. Arbitrator, it's important to know if the after the events insurance will cover all the costs, because it is not certain that literature will cover all the costs, considering that, first, this proceedings is too riskful, so after the literature is putting a lot of money in this procedure, and second, it is not even clear if claimant will be capable of paying the premium of literature. In this case, it's important to disclose both of the agreements. First, to know that if ATJ funding will cover all the costs of these proceedings, and if ATJ funding will not cover all the costs of these proceedings, if the after the event insurance of literature will cover all the costs that wasn't paid by ATJ funding and claimant.
Is Uson anything else on jurisdiction? No. So we'll move on to the merits, starting with Mr. Padilla from claimant.
Good afternoon, members of the Arbitral Tribunal. My name is Henrique Padilla, and I'll be addressing claimant submissions on the merits of the dispute. Claimant, which is worldwide, the seller and respondent, Darwin Natural Foods, the buyer, concluded the sales agreement for the purchase of 3,000 vanilla orchids with a variation of plus minus 10% of the final quantity. However, during the performance of the sales agreement, respondent breached his contractual obligations. Claimant, to avoid further losses, concluded a cover sale, which now respondent deems unreasonable. Nevertheless, respondent claims that its non-performance would also be exempted in the present case due to an impediment. However, that argument shall not be sustained, since claimant will demonstrate that first, respondent is liable for damages under Article 79 of the Convention, and second, that the damages must be equivalent to $3,300,000 US on the basis of Article 75 of the CSG. Before addressing my first argument, it is important to note that respondent's non-performance is incontroversial in the present case, as it did not obtain all the necessary import permits as required by Article 5.1 of the sales agreement. Therefore, claimant is entitled to pursue damages under Article 61(1)(b) of the Convention, since there is no impediment that would exempt respondent's non-performance. A party can be exempted from an impediment under the sales agreement on Article 12. Article 12 of the sales agreement, Article 12.1 of the sales agreement brings up a list of non-exhaustive events that may qualify as an impediment, but it doesn't bring the criteria that can be used to analyze if an impediment indeed occurred. Nevertheless, you must also analyze if an event is an impediment through the criteria of Article 79(1) of the Convention of the CSG. Under that article, there are three requirements that must be met for an event to be an impediment. First, it must have been beyond the party's control. Second, unforeseeable at the time of contracting. And third, the aggrieved party could not have reasonably overcome that impediment. Furthermore, according to Professor Ingeborg Schwenzer, the event must have been the sole purpose for why that party was not able to perform. Also, members of the tribunal, these three criteria are cumulative. If claimant demonstrates that only one of them is not met, then respondent is not exempted. Claimant does not contest that the first and second criteria were met. However, respondent had multiple occasions in which it could have overcome the consequences of the appendix change, but it decided not to do so. The impediment which respondent claims would have exempted it is the appendix change of the CITES convention. Under the convention, species are placed under Appendix 2 and Appendix 1. If a species is in Appendix 2, no import permit is required. But in Appendix 1, that becomes different. An import permit becomes an obligation for the party to commercialize the species. In the present case, the first news that the vanilla orchids would be altered from Appendix 2 to Appendix 1 started circulating on September 2023. However, the appendix change only came into force on 1st February 2024. That gives respondent a 4-month time period to be able to obtain the import permit. However, it decided not go after it, even though there was already a potential risk of the appendix change coming into force.
Mr. Padilla, if I may, I follow your argument, and I'm just afraid it's a bit tainted by hindsight bias, because now it really seems that the change would be relevant. But if we read Article 15 of the CITES Convention in 15.1c, I think that respondent would be legitimately entitled to expect that any change that would have occurred between Annex 2 to Annex 1 would be organized to happen within a 90-day framework that is provided in this article. So, and this immediate change appears to be unheard of. So, wouldn't this authorize respondent to wait a while longer and to check if they would have those additional days to change?
Mr. Arbitrator, what we must analyze is respondent's behavior. It is an international party in a sales agreement of a perishable good, and respondent should have been diligent. And at the first time it was announced that an appendix change could have occurred, it should have gone after the permit. The 90-day time limit, yes, in the present case, it was the application of the CITES new legislation was immediate. A respondent should have been diligent. It could have pursued the import permit before, but decided not to go after it. Also, respondent might bring up the fact that under CITES Resolution 12.3, all import permits that obtained prior to an appendix change become obsolete after the appendix change comes into force. However, that resolution is only a recommendation. There is no evidence in the case files as if Equatoriana did indeed adopt this resolution. Furthermore, members of the Arch Tribunal, respondent could have applied for anticipatory permit. Equatoriana, when there was a case of a species being included into Appendix 1 of the Convention, would oftenly issue anticipatory permits. After the first notices of the appendix change, the parties got together in a meeting and discussed the consequences the appendix change would have on the contract. On that meeting especially, respondent assured to claimant that it would pursue an anticipatory permit. However, it did not go after one, believing that the 90-day time of enforcement for the new legislation of CITES would occur. Members of the tribunal, clause 5.1 of the sales agreement is clear. Respondent had the obligation of obtaining all the necessary import permits. It assumed the risk that later on made the whole sales agreement not occur, and that cannot be considered diligent in the present case. Respondent had multiple occasions to go after the import permit, but decided not to do so, assuming a risk and thus proving that its non-performance was not caused by an impediment, but rather because of its own non-diligence. Nevertheless, respondent is not exempted in the present case, and claimant is entitled to pursue damages. Now, regarding my second argument, claimant shall demonstrate that the cover sale is valid and must be used to calculate damages under Article 75 of the Convention.
Sorry, counsel, if I can interrupt just before that. I'm wondering if we appreciate that your argument is based on Article 79, but if that argument fails, do you think there is a residual role for force majeure under the contract?
Madam Arbitrator, as claimant has demonstrated, clause 12.1 of the sales agreement only brings a list of non-exhaustive lists of events that may qualify as an impediment. But if the clause 79 of the sales agreement of the CSG is not met, claimant believes that under the sales agreement, respondent would still have breached its contractual obligations, since under clause 12.2 there is an obligation for the party who is being affected by an impediment to inform the other of the impediment in a 5-day time limit. In the present case, respondent became aware of the impediment on 1st February 2024. That was when the appendix exchange came into force. However, it only informed the claimant on 10 February. That is 9 days later. Therefore, if the tribunal is not satisfied that respondent would not be exempted under Article 79, it still breached its contractual obligations under Article 12.2 and therefore is not exempted. Now, moving on to the cover sale, under Article 75 of the Convention, there are 3 requirements for a cover sale to constitute and be valid under Article 75. First, it must occur after the avoidance of the contract. Second, on a reasonable time. And third, on a reasonable manner. Members of the tribunal, according to Professor Engelbert Schwenzer, if a party has indicated it will not perform its contractual obligations, then there is no need for the cover sale to occur after the contract is avoided. And that is exactly what happened in the present case. The tribunal can accompany me to page 59 of the case files, which is page 61 of the PDF. This is the procedural order number 2. The tribunal with me? Yes. On clarification number 28, it reads, and I quote, the respondent formally notified claimant of its inability to perform the contract as a result of a force majeure event, and it reads in the after. No written notice was issued. In his first phone call of 10 February 2024, Mr. Obvious informed claimant of the new development in Ecuatoriana in relation to import permits, and that while the permit would definitely not be granted in time
Sorry, Luis, I can't hear. Can you hear me?
Do you hear us now?
Yeah, now I can hear. Thank you.
So we are back. Let's carry on.
Following on, Mr. Arbitrator, as the cover sale was concluded on a reasonable timeline, considering the urgency, it was valid. But regarding the manner, it was also valid as well. In the present case, the price of vanilla orchids was already declining after the appendix change. After the new legislation came into force, sellers rushed to sell their vanilla orchids, while buyers were hesitant to buy, believing that the government Ecuatoriana would pursue a more restrictive approach to their commercialization. Claimant was running the risk of not obtaining any offer at all. That's why concluding the contract with Herbal Cosmetic was the most reasonable it could do. It had a very tight time limit until April, and the goods were perishable. Nevertheless, the cover sale was concluded on a reasonable manner and time as required by Article 75 of the CSG. Now, moving to my second
Sorry,
argument.
I'm not sure if I just to interrupt. Sorry, I don't know if I missed it earlier, but I wanted to ask whether the cover price reflects market conditions. So that's the first question, and a follow-up would be, why is 3,300 orchids the correct quantity for calculating damages?
Madam Arbitrator, before answering your question, I see my time is running out. Give another 1 minute to.
Yes, please go ahead.
Madam Arbitrator, at the time of the avoidance of the contract, the price was of $1,100 per vanilla orchid. The price accepted in the cover sale was $1,000, $100 difference. However, this price is considered reasonable since at that time, the price for vanilla orchids was already on a downfall. Had claimant waited any longer to find another suitable buyer, it could have ended up accepting an unreasonable price. That was not the case. Regarding your second question, Madam Arbitrator, claimant is the party who is entitled to select the final quantity of vanilla orchids, and that would be 3,300. Since under the PO2, it is already determined that the plus minus 10% clause added in the contract, one of the reasons it was added was because claimant had to, from its annual production, almost 10% of all the vanilla orchids were lost. To avoid these losses and still being able to complete the sales agreement, they added this clause into the contract. With that, members of the tribunal, claimant reinforces its submissions and thanks the tribunal for its attention.
I would have one question on the quantum and the amount of your claim, Mr. Padilla. Well, I understand that under the CISG, you can use the price of a cover sale in the case at hand. And I also understand that CISG is based on the principle of full compensation. However, on this specific contract, we have clause 9.2, that is an exclusion of liability clause, and stipulating that neither party is liable for indirect, incidental, special, or consequential damages, including loss of profits. So in your transaction with Herbal Cosmetics, there was a stipulated price, which I suppose also includes your company's profit, and you're using it as a basis for claiming damages against respondents. So how can the tribunal deal with this clause 9.2 in this case?
Mr. Arbitrator, just to confirm I have more time to answer your question. Mr. Arbitrator, in the present case, there was no loss of profit. What happened is respondent did not fulfill its obligations, and now claiming is seeking damages for the non-performance that respondent caused with. The loss of profit, for instance, is if claimant would have used that money later on, or would have used it after the sales agreement was concluded. Therefore, there was no loss of profit, and the damages must be equivalent to $3,300,000 US on the base of Article 75.
I see your point, but I just want to stress and to hear your argument. So in the price of the alternate transaction, isn't there a component which is your client's profit? Shouldn't this be taken under account in this case or excluded from your compensation based on clause 9.2?
No, Mr. Arbitrator, because in that transaction, what happened is that after the cover sale was amended, the parties decided to divide the transaction in installments. The first installment, which only considered the vanilla orchids that were to be sold to respondent, were based on $1,000. The other installments that came afterwards are totaled differently than the orchids that were to be sold from respondents. They are also part of the previous agreement of Herbal Cosmetics and claimants. Thank you.
Anything else from?
No.
Okay, so we'll hear now from, thank you, Mr. Padilla. We'll hear from respondents. Ms. Villas-Boas, you have 14 minutes.
Members of this tribunal and opposing counsel, once again, good afternoon. Honorable arbitrators, claimant would have this tribunal believe that what stands before us is merely a fence, a small regulatory inconvenience that respondent could have simply climbed over with a bit more effort. However, what initially seemed to be a fence soon turned out to be an unsurmountable wall, when what began as a regulatory requirement soon turned out to be complete legal impediment, with Equatoriana's shift to a restrictive position in February 2024. In light of this, respondent makes two submissions. First, respondent is not liable for failure to perform under Article 79 of the CISG and under Clause 12.1 of the sales agreement. And two, subsidiarily, in the unlikely event that this tribunal finds that damages shall be awarded, they must be calculated exclusively on the basis of Article 76, that is, the difference between the price market and the original sale, and not based on Article 75, since here there was not a valid cover sale. First and foremost, respondent does not deny that under Clause 5.1 of the sales agreement, it had an obligation to procure the necessary import permits. However, unlike what's stated by claimant, this is not an unexcusable failure to perform or a breach of contract, but rather an unavoidable impediment. Here, claimant mentions three requisites: externality, unforeseeability, and unavoidability for the application of Article 79, all of which are met, which was, in this case, even conceded by claimant itself in relation to the two first points. Secondly, claimant conveniently refuses to bring to this tribunal's attention the exact wording of the clause 12.1 of the sales agreement. So please allow respondent to bring this tribunal to page 13 of the case files, page 15 of the PDF, to take a better look at what was established in the force majeure clause. For reference, we'll look once again at the sales agreement at clause 12.1 on the page 13. Do you follow me? Here we find, and I quote, "A party is not liable for failure or delay caused by events beyond its reasonable control, including but not limited to acts of God, extreme weather, epidemics and pandemics, quarantine restrictions, embargoes, and among others, government measures." Here, the criteria is very clear. We need a reasonable way to avoid the impediment for Article 12.1 to not be applicable. And here there was no reasonable way out of the impediment that was presented by the restriction of commerce. Claimant wrongly affirms that, and I quote, "An import permit is required for commercialization of the vanilla orchids under Appendix 1." That's not correct. Appendix 1 excludes the application of the vanilla orchid from the commercialization, and that was the impediment that was rendered beyond control after the shift of Equatoriana's governmental position to a restrictive approach of the site's criteria. First, let us take a step back and see the fact that claimant did not bring completely to this tribunal. On September 2023, there was a suggestion of the site's committee to upgrade the protection of the vanilla orchids. However, this was a non-binding suggestion which was strongly opposed by both Equatoriana and Mediterranean. Here, respondent had reasonable grounds to believe that the recommendation would not prevail, or in any case, even if it did, it would still be able to get the import permits required. Claimant states, and I quote, that respondent assumed the risk that prevented performance. However, no risk was assumed here since respondent had all reasonable grounds to believe that performance would still be possible. In the first case scenario, even if the site's committee adopted this measure, they usually had a 90-day period before the enforcement of its measures. And this 90-day period falls well within the period of delivery if the decision was taken on the 1st of February. Here,
Ms. Villas-Boas, I'm sorry to interrupt you. I just want to make sure I understand what we're talking about when we talk about the impediment. So if I understand, I think both parties seem to be on the same page that whatever impediment we're talking about, it was the move from Appendix 2 to Appendix 1, right? Once the suggestion was made by the committee, both parties interacted. And if I understand correctly, respondent indicated it did not think there would be any issue getting a permit later on, an import permit. Why wouldn't that be an assumption of risk?
Mr. Arbitrator, here the impediment, according to respondent, was not in fact the effective change into Appendix 2, but Equatoriana's subsequent shift to a more restrictive approach. This leads me directly into the second scenario. Even if the 90-day period was not used, which, for the record, there was no precedent case in which the immediate effect was adopted, even in that case, Equatoriana still adopted the site's obligations leniently, and it has a historical precedent of an exception to the import requirement, granting import permits if any research purpose was present in the trade. This was clearly the case here, since respondent would have used at least 300 units of the vanilla orchid for research purpose on genetic studies. So even if reclassification did prevail, even if the 90-day period was abandoned, which had never occurred in the history of the country yet, there was still the exception that was a historical precedent of Equatoriana that respondent could have relied on. However, the scenario completely and unforeseeably changed in early 2024.
And I understand your point, Ms. Villas-Boas. I just want to go back to December 23 because from my reading of the files, what appears to have happened in that month, and I want to hear your client's view on this, is that your client undertook the risk that they would deliver the necessary permits if they ever became necessary. So I do understand your comments that following that year, there was reasonableness in hoping that it would be possible, and then the changes happened later. But in December 2033, hasn't your client made an assurance to claimant in the sense that this will be our problem? If anything happens, we'll be able to deal with it, creating what I would call a guarantee clause that now would make your client liable, even if it is at no fault of yours.
No, Mr. Arbitrator, to quote the same Professor Schwenzer that the counterparty brought, and I quote, performance of such acts, the one established in the transaction, in some cases depends only on the buyer's diligence. In others, it needs an administrative authorization, and here the buyer cannot be held liable for a refusal of such authorization. Respondent never denied that it had the obligation to procure the permits. However, here there is an exemption of liability since there was no reasonable measure that respondent could have taken to obtain it, since this was a sovereign act which qualifies as external, since this measure was unforeseeable and unlike any of the precedent history, and third, since it was also unavoidable. Here, claimant makes a demand that respondent had procured anticipatory import permits, and even mentions Resolution 12.3 that expressly states that in a contracting member of the size committee, the import permit obtained before reclassification would expire. However, it still makes the unreasonable demand that respondent had applied for this anticipatory permit, even though it was not an urgent measure, since respondent had reasonable grounds to believe it would be able to obtain it. And secondly, it wasn't even a mandatory measure, since there was no guarantee that the sites conference would in fact adopt this new stricter regulation in December 2023 when claimant made this unreasonable demands. And lastly, this brings me to
Counsel, sorry if I may interrupt. What specific steps did you take or the respondent took after the listing became effective to overcome it?
On the 5th of February, soon after the inclusion of the orchid into the new appendix, respondent applied for the necessary import permit diligently in an effort to guarantee this obligation. However, on the 8th of February, in a complete unexpected manner, the authorities of Equatoriana issued a statement revoking its previous exceptions and stating that from that point on, Equatoriana would adopt strict regulations of the sites, impossibilitating the importation of the vanilla orchid. And on the 14th of February, the import permit was refused. This leads me to my next point. Here, under clause 12.2 of the sales agreement, the 5-day period was complied with. The impediment did not materialize on the 1st of February, since then there was no indication that Equatoriana would effectively deny the import requirement that respondent made on the 5th of February. The impediment came on the 8th of February with a governmental declaration to impose stricter regulations. And thus, the phone call that Mr. Albias made to claimant on the 10th of February, only 2 days afterwards, plainly fits in the criteria. Here, thus, respondent would like to bring to the tribunal's attention the Ukrainian corn case judged by the International Commercial Arbitration Court, where a Swiss buyer purchased corn from an Ukrainian seller, but failed to deliver since the Ukrainian legislation for an export permit was changed, thus rendering this transaction impossible. The ruling of the tribunal was that the seller was under an exemption of liability for failure to perform, and thus did not amount into damages due to an impediment beyond control. Here, as proved, the impediment was beyond respondent's control, since there was no measure it could have taken to avoid the Equatoriana government denying its permit requirements, and it was not demandable that respondent, in a futuristic anticipation, having no idea of the complete view of this case, could have taken precautions before the decision had even been made. However, even in the unlikely event that this tribunal finds that damages shall be awarded, they must not be calculated under Article 75. The counterparty cites, once again, Professor Schwenzer, to state that the notification would be exempted when it is clear that a counterparty would not perform. However, this quotation is thus distorted. The requirement here is that not only it is clear that the counterparty would not perform, but you need to have a reason for a fundamental breach of contract. Here, Mr. Albia's statement was not that it would be absolutely impossible for the contract to take place, since they were still conducting internal reviews. Here, what was capable of being inferred was that the delivery could not be complied at that time. And Article 25 of the CISG establishes a duty to provide an additional period of time for the breaching party to attempt to comply under a breach of contract. And here, the case cited by the counterparty, the iron molybdenum case, was also distorted, since under that case, a further time to attempt to compliance was granted to the breaching party, and only when, after that time, it did not comply, there was a fundamental breach that would enable the avoidance of the contract. And here, previous avoidance remains fully necessary for the application of Article 75, as stated by the counterparty itself. In fact, claimant conducted its cover sale on the 15th of February 2024. However, it continued effectually negotiating with respondent until much time after. In this sense, I would ask the tribunal to follow me to page 13 of the case files, page 19 of the PDF, and let me know when you are there. For reference, we'll look at the Mr. Harmon, respondent's head of sales, statement. Here we find on point 14 that, and I quote, after Mr. Albias had confirmed that information on the 23rd of February and following further unsuccessful negotiations, we finally terminated the contract with respondent on the 1st of March. That is, the contract was plainly valid for 15 days after the cover sale.
But going to the previous paragraph, there was news on the press stating that your client would discontinue the purchase of that spice line. So I understand your interpretation of the law, but in practice, wasn't it reasonable to consider that you wouldn't be taking those orchids anymore?
Mr. Arbitrator, I see my time is elapsing. I would like to ask for additional time to answer the questions.
1 minute. You can answer my question and then we'll grant you another minute.
Okay, thank you. So here there was no official notification from respondent that this line would have been discontinued until the 27th of February, which was when negotiations stopped. So after the cover sale, and claimant could not have based on rumors of the market to attempt this cover sale. Here the price was for, I see that my time is elapsing. Could I ask for 2 minutes to finish my submissions?
Yes, please go ahead.
Okay, so here, claimant never further demonstrated the urgency of entering into this transaction or that the price was reasonable. Here, there was a price market dropped to 1,100, and yet, the claimant accepted the conditions of $1,000 per vanilla orchid. Here, this price is not reasonable because claimant never demonstrated that there was an effective urgency since it only waited for 5 days and there would be no perishability of the orchids until June, and he even accepted to deliver the goods after the original transaction would have been delivered. It further demonstrated that it did not demonstrate that better offers were available or that it attempted in any way to find another buyer besides herbal cosmetics. Thus, the substitute transaction is not reasonable neither in its time nor in its price. So Article 76 should be applied instead. That is, covers the original transaction price difference from the price market at the time of avoidance, that is $1,100. And lastly, the quantity demanded by claimant is not reasonable. Here, the contract established flexible terms, and these flexible terms were up to respondent to determine the exact amount of orchids that would have been taken, since it was the one to arrange transportation and the only one that could define how many orchids the transportation could effectively carry. So here, to avoid a speculative exercise, the damages must be calculated on the minimum amount, which was the only amount that respondent was obliged to take. With that, totaling $2,430,000. I end my submission and thank the tribunal for the time.
Thank you, Ms. Villas-Boas. Any questions from the tribunal right now?
Just one question. Is it possible for partial or delayed performance if full performance could not have been made?
I would just like to confirm I will have the additional time to answer this question.
Mm-hmm.
Here, in the end, it turned out to not be possible to enable delivery. However, claimant did not have that information, and neither did respondent. Neither of the parties knew that the contract would effectively not take place in a definitive way, which was this requirement set out by Article 75 of the CISG until the 27th of February, well after the cover sale had already happened.
See that we have no further questions. We'll turn back to Mr. Padilla for another minute.
Members of the tribunal, as quoted by respondent, Professor Schwenzer is clear. Some actions require the buyer's diligence, and that is something respondent was not in the present case, diligent. It had the opportunity of obtaining the import permits 4 months before the exchange came to force and could have applied for an anticipatory permit, but decided not to do so. Thank you.
Villas-Boas, servo.
Honorable arbitrators, it is very easy to fabricate a duty of diligence after you know the outcome of the case. Here, it was not demandable that respondent had applied for an early permit since it was not sure even that it would have been accepted and still applicable at the effective time of delivery, nor that there was any urgency to obtain it. Thank you.
Any questions from the tribunal?
No further questions.
So that concludes our hearings for today. Thank you, counsel, for your submissions. We'll deliberate in another room and come back to you for the results.
Gente, sai.
A gente vai para outra sala. Ok, fica bom. So we are back. First of all, it was such an interesting session. Thank you so much for your deliveries. We learned so much by hearing the Moody's, and we feel like energized after a session like this. I was a Moody in 2008, and I see that you're getting better each year. So we were really impressed as a tribunal. Before we announce the result, we will, of course, take the time to say thank you to Adriana in New York, to Pedro, who joined us here today, and also to our organizers, João, who has been here 2 days, and Agati and all the team. They have been very committed to organizing this. We also have the IT team behind the screen here, Vinicius, all the IT guys who have been with us. And we decided that there won't be any feedback from the panel for you today because this is a live session and you have been doing so well that, of course, you can all do tweaks and things for Vienna, but it's not like you are needing our comments. So we'll, of course, be available after the session if you have any doubts and would like to cover anything else. But, well, getting to the so expected news, this was, as I said, a wonderful session, both on jurisdiction and the merits. It was a close call. We thought that each speaker was, if we were to give you grades, we would give you maximum grades because the performance was outstanding for the four of you. But considering the deliveries of today and what we saw in the session, we decided to grant the competition to claimant to put. And well, this is the 12th edition of the Souto Correa Pre-Moot. Thank you so much, everybody. We look forward to seeing you next year, maybe as coaches or as Moody's as well. So thank you so much and congratulations.
Thank you.
This closes our broadcast for today. Thanks so much.